Yes, so our chair, Charlie Van Winkle, recused himself from the hearing tonight. He is present in the room, and my name is Brian Birch, and I'm the vice chair, who will be acting as chair tonight. So we'll start by just reading through our rules and procedure again. So this is a hearing regarding the appeal of Nicholas Burrell, Heather Sikorsky, Russell, and Patricia Vogel pertaining to the zoning administrator's decision that a forestry operation being conducted by Gordon Williamson on property owned by Joseph and Ann Tisbert is an exempt forestry operation and not subject to the Underhill land use regulations. The subject property is located at 633 Pleasant Valley Road in Underhill. The appeal request is subject to review under the 2011 Unified Land Use Development Regulations as amended March 3rd, 2020. And the purpose of this hearing is to review the appeal and supporting documentation to determine whether or not the zoning administrator made an appropriate decision, to review the regulations and other municipal ordinances pertinent to the appeal application, and to determine whether alternative relief is appropriate by approving a variance. Copies of our rule and procedure that the board follows are available for review at the front counter downstairs and can be obtained from the planning and zoning administrator. The order of speakers tonight will be, first we'll hear and ask questions of the planning and zoning administrator. Then we will hear and ask questions of the appellants and or their representatives. After that, we will give other people in the room a chance to speak. And under our rules and procedure, each speaker is limited to 5 minutes. However, that time can be extended upon request of the board and majority of consent of the board. After all interested parties in the room have had a chance to speak, the appellants and or the representatives will have the opportunity to respond. And then finally, the board will be able to solicit final comments and questions from any party. And so please tonight, all speakers address their comments to the board, not to other parties present. And board members may feel free to ask questions of any speaker. So I will now ask if there are any state or municipal representatives present and acting in their representative capacities. Hearing none. There is an interested party info sheet available to all attendees at the front counter downstairs or from the planning and zoning administrator. Please review it for further information. Only those interested parties who have participated either orally or through written statements in a DRB proceeding may appeal a decision rendered in that proceeding to the Environmental Division of Superior Court. If you are the appellant's representative, or an interested party who wants to participate in the hearing, we will have you come up to the witness chair and clearly state your name, residential address, and mailing address if it differs. With all that said, I am now going to swear in those present who wish to speak tonight. All individuals who plan to testify tonight must take the following oath by responding "I do" at the end. So, do you hereby swear that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth under pains and penalties of perjury? Everyone? Great, thank you. So I'll now ask if there are any conflicts of interest or have there been any ex parte communications on part of board members?
No.
Nope.
No, but I'd just like to say, Penny Miller, that I found out my husband purchases our fuel wood from Gordon.
Okay, and I'm taking it that you feel that you're able to still participate tonight?
I feel like I can still participate tonight.
Be
fair.
All right, thank you, Penny. So at this point, I'm going to enter into the record the information package that was sent by the Planning and Zoning Administrator prior to the hearing. The information included in this package relevant to the hearing is And Matt, you may need to help me with these exhibits. I have it as Exhibit A, the DRB agenda. I have Exhibit B, the 7 days notice from April 17th. I have Exhibit C as the certificate of service from April 17th. I have Exhibit D as the appeal request application dated April 15th. And I have Exhibit E, the zoning administrator decision and related documents. That's dated April 1st. And then I believe we have a new exhibit submitted right before the hearing. So we will label this Exhibit F. Are there two?
Well, on the letter from
Is this a new exhibit, the letter
Trish Vogel.
as part of the letter from
Trish Vogel.
there? Okay. Okay, so Exhibit F will be the memorandum of appellants dated May 6th. And Exhibit G will be a letter to the Development Review Board from Trish Vogel, Patricia Vogel, because she was absent from the tonight's hearing. And no additional exhibits. These two are the two new ones. Okay. Okay, Exhibits F and G. So these exhibits are available and will be available in the Burrell, Sikorsky, and Vogel appeal request file titled ZA1 at the Underhill Planning and Zoning Office and on the town website. So are there any questions on our rules and procedure? That was all of them. So, okay, so now we can begin testimony. As we stated earlier, we'll start with the planning and zoning administrator. So Brad, you can come up and the floor is yours.
Testing. Okay. I'm Brad Holden. I'm the interim zoning administrator, and I'm also the town administrator. I'm not here in that official capacity as town administrator tonight. This is the second time that I've had to fill the role of zoning administrator when we have a vacancy. But zoning's not something that I'm not familiar with. So I have a degree in land surveying. I've worked in that profession up until 2020 when I decided to retire from practice in Vermont after 30 plus years, at which time I accepted the position as Underhill Town Administrator. My entire career has been surrounded with federal, state, and municipal rules and laws. I've been appointed to several legislative committees in which I've helped draft legislation with lawmakers still in effect today. For example, parcel data standards, highway condemnation, and timber trespass, just to name a few. I've served as a special master for the Chittenden Superior Court, and I'm a past select board member. As a land surveyor, I was licensed for the protection of the public. Unlike some professions that solely advocate for their clients, my opinions have to consider all parties involved. While I'm no longer practicing, that charge still runs deep within me, and I feel it also carries over to the role of an administrator, zoning administrator. I'm sympathetic to the concerns of the appellants, and after careful consideration, I'd exercise my best judgment in order to come to a conclusion. State law puts limitations on municipal bylaws. And make no mistake, if this timber being processed by Gordon Williamson was coming from the property where it's being processed on, there would be no question that this type of operation would be exempt from our regulations. In 2018, the Commissioner of Forest, Parks, and Recreation spearheaded legislation, and the General Assembly passed the Vermont right to conduct forestry operations and forestry practice in compliance with acceptable management practices for maintaining water quality on logging jobs in Vermont. So logging is primarily done in the wintertime under a very narrow time, under a very narrow window of time. And given the impacts of climate change, the window is getting narrower every year. Forestry operations are taking place on managed timberlands, and these operations have to freeze the ground in order to remove the logs from the woods in order to prevent erosion. And as well as there's not often enough room on the harvest site to process products like firewood. So unlike milk, timber is not considered perishable, when in fact it actually is. In late February, early March, the town posts its roads for mud season. When the roads are posted, milk is still allowed to be trucked on town highways, but logs may not necessarily be allowed to be trucked on town highways. The posting takes place near the end of the logging season, so some log products have to be trucked off-site where they can be processed at a later date, such as firewood. If they are not removed from the forest when conditions permit in order to be turned into something useful, they risk the chance of being left there to rot. So to me, it makes sense to have laws that allow for forest products to be processed at a later date off the harvest site. The use of portable wood processing equipment is allowed off the harvest site so long as it meets 5 criteria. I'm going to address the 4 obvious criteria and leave number 2 for last. The person conducting the forestry operation owns or has permission to use the site for the forestry operation. So as in the evidence, we have a timberland management lease where Mr. Williamson has the permission to operate. The site number 3, I'm skipping 2. 3, the site has been used by forestry operation for 12 or fewer months in any 2-year period, or 24 or fewer months in any 5-year period. Number 4, the forestry operation complies with all applicable law, and only portable, non-permanent equipment is used to process products at the site. So finally, going back to number 2, the forestry operation was established prior to surrounding activities that are not forestry operations. This wording is obviously vague. What does surrounding mean? And what does activities really mean? As I stated in my decision, it's my opinion that if the legislature meant to include residential dwellings, why didn't they say so? After all, where could someone cite a forestry operation that wouldn't affect a residence? Instead, it's my opinion that these activities that are not forestry operations, obviously a residence is not a forestry operation, but let's take golfing, for example, which is undoubtedly an activity. Suppose there was a well-established golf course, open for business every day from spring until fall, and the 18th green was sited right near the property line, and a forestry operation such as Gordon Williamson's moved in. That's the type of surrounding activities that I believe the law is meaning to protect. The same could be said for an infant daycare or school. The Development Board's charge is to either agree or disagree with my decision and not to decide whether this constitutes a nuisance. Our nuisance ordinance falls under the select board's purview. I believe the expectation is that these types of operations would occur during working hours when most residents are away at work, and thus why the law puts limitations on hours of operation. So that's all I have to say.
So does anyone on the board have questions for Brad?
Residential activity. What about activities that might occur within residences?
I'm not sure what you're referring to when you say residential activity. It's activities that are not forestry operations. Is what the law says.
So, but you were saying something about residential.
Well, residences. What did I say exactly? I said residences are obviously not a forestry operation, right?
Okay.
So we're talking about things that are not a forestry operation, such as a golf course.
Okay.
Right? The wording is extremely poor and very vague. But again, I say if the legislature meant to include living or habitable residents, they should have said so. After all, why would you have a law to prevent nuisance lawsuits if there's no place, there's hardly any places you could go in Vermont now where you could set up a forestry operation where you won't be affecting someone else or someone won't hear it. It's no different with farming. The right to farm. I mean, well-established farms, you move in next door, they spread manure. That's their livelihood. So I think the time limitations were put there for a reason. It's not like it's a 24/7 operation. I don't know if that answered your question. But
Brad, I had a question. Trying to find it, but in your decision, I believe, or maybe it was in one of the supporting documents, you made a mention to state statute, and then state statute that was amended more recently, maybe like 2018. Is that true?
right, as I just said in my statement, in 2000. So prior to 2018, a forestry operation was always considered to be on the harvest site. To be exempt, it had to be on the harvest site. In 2018, the General Assembly and the Director or the Commissioner of Forest Parks and Recreation expanded that definition to include areas that are not on the harvest site. And so long as they meet the 5 criteria.
Okay. Thanks.
I hope no one's allergic to cats. If you are, please let me know and I'll pin him downstairs. And be careful with him, he can be aggressive. Just saying. We've all spared some blood. Thank you.
So if there are no other board members' questions, we'll have an opportunity to ask questions, Brad, at the end. We can now hear from the appellants and their representative.
Thank you all and good evening. My name is Justin Barnard. I am an attorney for the appellants here, Russ and Patricia Vogel, Heather Sikorsky, and Nick Burrell. Nick, Heather, and Russ are with us tonight, and Patricia could not be here, but as was covered earlier, she submitted a written statement in lieu of being here to testify. So I want to thank you for coming out on what is one of the most gorgeous evenings of the last couple of weeks and sitting in a room to hear this appeal. It is of immense importance to these 4 residents who have reluctantly raised this issue and pursued an appeal. This firewood processing operation is having a huge impact on their quality of life. It's very disruptive, it's very loud, and I could have them each stand up today and talk to you about the sort of disruption that has worked on their ability to use the properties. And you'll see some of that in Patricia Vogel's statement. But I don't want to keep you from getting out and enjoying this evening. And I don't think it's actually relevant to what you need to decide. Nor, frankly, is the facilitation of good timber harvesting practices. I don't think my clients disagree that you should be able to truck timber off at an appropriate time of year when the roads are still frozen and process the timber off-site. Your zoning regulations explicitly allow, as a conditional use, sawmills in the rural residential district. But the answer to this appeal is pretty straightforward. So I'm just going to walk through our position, probably well under the 5 minutes we have, and then happy to answer any questions. So first off, there's no question, I don't think the interim zoning administrator disagrees that this operation is not permitted under your zoning regulations. All of these properties are in the Mount Mansfield Scenic Preservation District. If you look at table 2.1 in your zoning regulations, a sawmill is clearly not a permitted use in that district. Again, it's only permitted in the rural residential district as a conditional use. Article 11.2 of your regulations defines a sawmill as a wood processing facility, including structures and yard areas where logs are stored and processed into lumber and other wood products. That's exactly what's happening here. Mr. Williamson is trucking in timber from off-site and piling it, storing it immediately adjacent to my client's property in large stacks. You can see in Exhibit C to our submission, there's some pictures of the stacks of wood directly adjacent to my client's property line. And he's then using a 48-inch slasher saw to help process the timber into firewood. This is a very loud activity. It's happening right by these residences. There is a limited carve-out in your bylaws for processing of timber that's harvested on site. That's not what's happening here. So clearly not allowed under your bylaws. The interim zoning administrator talked about 2 state laws that he believed might apply and bring this operation outside the scope of your local land use regulations. And while I appreciate the care that Mr. Holden took to consider this issue and consider these residents' concerns, quite frankly, he got it wrong. So the first law is a law that exempts certain forestry operations from any sort of local land use control. And forestry operation, as it's defined in statute, does include some primary processing of timber. But exactly like your bylaws, it only exempts those activities, only exempts the milling of timber when it's harvested on the site where it's being processed. So if you're bringing in timber from elsewhere, it doesn't apply. And that makes sense because otherwise every single sawmill in the state of Vermont would be outside of local land use regulation. And it's a loud and sometimes dusty operation. It's the sort of thing that local bodies have traditionally had the ability to regulate and determine where in your town it is appropriate for that activity to take place. So the statute that Mr. Holden was quoting from at length with these 5 criteria, it's 12 VSA 5756 and 5757. That is a shield law for nuisance lawsuits. There's one that you may be familiar with for farming operations, and it essentially says these are traditional activities that have value to our state, and we want to provide limited protection from lawsuits And provided that they meet certain criteria, those 5 criteria that Mr. Holden went through, you can't file a lawsuit in the Superior Court and seek damages for nuisance. It has no relevance whatsoever to your authority as a town to regulate and determine whether a sawmill can operate in a particular district. That is clearly within your authority. And, you know, it's not something that you're called upon to decide here tonight, whether this is or is not the appropriate place for a sawmill. That decision was made when you enacted your zoning regulations and you said sawmill is not appropriate in the Mount Mansfield Scenic Preservation District. So that's it. We would ask that the DRB find that this is in fact an unpermitted use in the district in which it's located and require that it cease operation. I do want to say though, you know, my clients, there's no animus here. There's no personal vendetta. That, you know, they are happy to have Mr. Holden continue his operation and make his living. They don't want to interfere with that, but it just has to happen somewhere where it's permitted. It's a portable sawmill. He can pick it up, move it to another piece of leased land in the appropriate district and continue his operation. What he can't do is do it, you know, right along my client's property line in a district where it is not permitted under your regulations. So I'm going to stop there and see if you have any questions.
Any questions? Or are we all set?
Penny Miller. May I call you, is
Justin.
it Justin?
Yeah.
So Justin, you are claiming that the zoning administrator, interim zoning administrator, misinterpreted this statute. And it's, I need to hear you explain it again, why you think it's misinterpreted.
Absolutely.
Because that's the crux of this. This is what we're deciding.
Yep.
Okay, thank you.
So what Mr. Holden was reading from was a definition section of a state statute that defines a forestry operation. That's 12 VSA 5756. The operative portion of the statute, what it actually says it does, is in 12 VSA 5757. It provides a person conducting a forestry practice a rebuttable presumption that the practice does not constitute a public or private nuisance as long as they comply with the acceptable management practices for maintaining water quality on logging jobs in Vermont and other applicable law. This, by the way, would be another applicable law. So this operates as a shield from lawsuits. It is not, there is another section of the state statutes that deals with what a municipal body can regulate under its land use regulations and specifically defines the type of forestry operations that you as a town do not have authority absolutely to regulate. This is something entirely different. This is about nuisance lawsuits. And I understand that it's dealing with the same subject matter, and in some cases there might be overlap, but we're not bringing a nuisance lawsuit. We're not asking you to declare it a nuisance. As the zoning administrator noted, that wouldn't even be within your bailiwick.
All right, then where would this statute apply? Where would it apply then? If you're saying it's a shield law, it would only apply in municipalities that say this is permitted in a district?
No, it would apply if a party went to court and filed a lawsuit against someone engaged in what this statute defines as a forestry operation. That logger, wood processor, could go to court and they could say, I'm entitled to a presumption that I can't be held liable in a court for civil damages for nuisance. So it's Again, we're talking about laws that define the ways in which logging can be regulated or someone can be liable for engaging in forestry operations, but these are two separate things. This law, and I understand you have counsel, you're going to consult with your counsel and they will advise you, but this law absolutely has no application to what you do.
So you're saying this law doesn't give permission for these operations, this particular statute. This statute has some other purpose. It's our zoning laws, our land use laws that give the permission.
Correct. If there are no other questions, I can yield my spot.
Yeah, thank you. So now if there's any members from the public who would like to speak, this is your opportunity to come up to the witness chair. When you do, just start by please stating your name and your address.
My name is Mike Timbers. I'm at 662 Irish Settlement Road. And I'm here as a neighbor of the Tisberts, Gordon, his wife. I've lived next to the Tisberts for 30 years. Their farm, Valley Dream Farm, has been agricultural in nature for that entire time. Lived across from the Butler Farm for the same time. I look at this situation as agricultural. You can call it forestry. I mean, you can call it a sawmill, but if you've ever seen a sawmill, this is not a sawmill. This is, someone who's trying to make a living in an agricultural area and processing a renewable resource, which more people should be using. And I want to go on record as being completely in support of this activity. As an adjoining landowner, and that's all I have to say.
Thank you, Mike. Anybody else? Yep, come on up.
My name is Vicki Johnson. I live at 621 Pleasant Valley Road. We are directly across from Gordon's operations. I will say that at this time, my husband and I do not consider the noise to be a nuisance. I certainly empathize with our neighbors. And sure, if there was a better place for him to do it, I'm sure Gordon would have selected that. I am not home during the week, but my husband is. I did ask him before I told him what I was going to say, if he agreed that did he consider the noise to be a nuisance, and he did not. Thank you. Sure.
Hi,
Thank you.
Vicki, this is Penny Miller. I just wondered, what did you say your address was?
621 Pleasant Valley.
All right, thank you.
I will say that also that Gordon did come to me at the beginning of last summer to let me know what his hours of operations were going to be, what he projected them to be for the summer. And one, which I thought was nice, I didn't feel like he had to do that. And then secondly, I felt that he pretty much stuck to it during the summer, maybe a couple of times when we'd had excessive periods of rain. Did he, work at some other time? So I did appreciate that. And that's what I would like to see us able to work it all out as neighbors and come up with some agreeable hours of operation. That would be the ideal situation for me. Thank you.
My name is Gordon Williamson, resident at 623 Pleasant Valley Road with my wife, Michelle. I'd just like to take a couple minutes and highlight a couple of things. Title 12 Vermont statutes, 12 VSA and 5756, it states that forest product means logs, pulpwood, veneer, boltwood, wood chips, stud wood, poles, piling, biomass, fuel wood, maple sap, or bark. It also states that a forestry operation means activities related to the management of forests, including timber harvest, removal, storage or stockpiling of vegetation or timber, pruning, planting, lumber processing with portable sawmills, reforestation, pest, disease, and invasive species control, wildlife habitat management, and fertilization. With that being said, I've talked to a lot of experts on this situation, some that actually wrote the law that the appellant's representative was focusing on, and I don't have to cut a single tree on Joe and Ann Tisbert's property to be an active on-site forestry operation. Right now, the land management lease that I am in with Joe and Ann Tisbert, I go out, I prune trees for them if they are inflicting any passage to their gravel pit, to their compost piles. I put a food plot in for wildlife habitat management to make the deer population, a better hunting area for hunters as well as other animals, turkeys, and other wildlife there. I also take care of, there's a plant that he cannot put in his hay when he does hay and bale on the property in that field. I rototill it into the ground. During the spring months and summer, if he requests it, I go around the edge of all of his fields and bush hog saplings. Take care of that so that it doesn't encroach any more on his fields than it already has. Those are all forest products. They are timber products, and they are mentioned in Vermont statute. I don't have to cut a tree. The logs that come in from offsite, as long as they are not being used in a developmental way, as long as there's no houses or stores or anything being used or built on those where the logs come from, if it's a forestry management process, those logs can be used in an off-site or on-site as firewood. It states that the legal protection that they have that he was talking about, it states if that there's no protection if it's becoming if it's a developmental thing. The protection is as long as you're an active on-site or off-site forestry operation, you are entitled to protection under that state law, the nuisance law. And this is exactly what my operation is. They're considering it a nuisance, or that's what I believe, because it's loud. It does make noise. Out of the whole calendar year last year, I cut for 79 days. I have every single day recorded. For every cord that I cut, my truck holds 2 cords at a time. The processor only runs above the noise limit for 1 hour. It takes me 1 hour to cut 2 cords and load into my truck. I then shut it off, take my truck, and I deliver. I usually only cut 2, depending on my orders, 2 cords in the morning and 2 cords in the afternoon. If I happen to get some really nice straight logs, they go through very fast, and it takes less than 40 minutes to cut 2 cords of wood and load into my truck, and then I'm gone on deliveries. This year, I have not started before 8 a.m., and I have not cut until after 5 p.m. I have every time recorded in my phone, and I have every date from last year recorded that I cut on the property. I have reached out to all of them and said that I'm willing to work with them as days of operation, hours of operation, or the position of the processor to where it creates less noise. Their only response to that was that they would like it moved to a different spot. There's no mediating. There's not been any type of forgiveness or or willing to work with me as in any of those parts. And they, from what I've gathered, they only feel that it's me trying to put it there to bother them or something personal. The reason that Joe and I put it there was that is Joe's worst cropland area. His soil does not drain. It's got a lot of blue clay underneath, and to make that a profitable hayfield or vegetable crop area, he would have to put in tile drains, which is a very expensive procedure. So he let me have that place. The reason we moved across from my property to that place is because we have a bridge that is unofficially rated for 65,000 pounds by Mike Weisel. My truck loaded with 6 or 7 cords of logs can be potentially 65,000 to 85,000 pounds, depending on how much it is. But not only at that time would I be impacting my wife and myself and our family from accessing our own property, I would be denying access to Dave and Pam Sills that also share the driveway. And I would be impacting Shane Steffens that leases property on the other side of the bridge that is a corridor along our driveway, and Joe and Ann Tisbert. It is only a right of way for us. So it is actually their bridge and their property. And I did not want to put that burden on a failed bridge, on them or myself, because the engineering, the replacement cost of a bridge of 4 very large I-beams is quite costly. And it's just not worth it for me to replace it. If there are any questions about my processor or anything else, I'm more than happy to answer them. Otherwise, that's all I have to say.
Meg Armstrong. I have a quick question. In the law, you said you talked to somebody that was involved with drafting some of these laws. The site is used for forestry operation for 12 or fewer months in any 2-year period, or 24 or fewer months in any 5-year period. From what you said, you're operating it some days almost every month, but not only 79 days in the last calendar year.
In the last calendar year, I operated 79 days out of 365. It's not, I have, last year was a very bad year, or this year actually has been as well. I had to put a new turbo on my processor. I was down for almost the whole month of July. I don't cut when I'm broke down. I had my previous log truck that I owned, it ended up having a cracked frame, so I couldn't operate it over the road. That was a $28,000 repair, or sell it and buy a new one, which I did. At that point, 3 weeks later, after I bought the new log truck, the transmission went out, and over the winter, I put $26,000 into that truck. This is not a cheap hobby. I'm in it, to try to there's not a lot of young firewood cutters in this town. Craig Walker is 84. Dennis Beloin is 80, 79, 80. Anybody that tries to get firewood, good luck. It's been a horrible logging weather for the past 3 years. I couldn't get wood. That's why I bought a logging truck. Luckily I have my CDL, so I'm able to branch out a little further and create a rapport with local loggers. For the record, every log that comes into that property doesn't come from any more than 10 miles. It supports everybody in this town that has a logging operation going on through Jamie Richards, my logger there, or Ben LePesker, who's in Lamoille County. And then I don't deliver more than 20 minutes from the landing on Pleasant Valley Road. It goes to Underhill, Jericho, Cambridge, Jeff, and sometimes Westford. It stays right here locally. And, it's going to be even harder to get firewood with the way the weather is going. Like Brad said, it's a very closed window of operation for logging. We don't get a pass like sap trucks or, milk trucks or heating trucks, with propane or gas. It's make or break, run or die time in the spring before the roads get posted. And thankfully I work very closely with Russ Clark and Eric Buzan to make that happen before the roads get posted and I get shut down for spring, for mud season. And I don't cut. I'm blessed to be able to cut. I started, I think 2 weeks ago cutting. I never would have expected that I'd be cutting before May 15th this year, as wet as it's been and as much rain as we've had. It's a blessing to have a landing that's somewhat dry to where I can get in and out of it and actually provide firewood for people.
And the other question I had, you said you run maybe 2 or 3 loads a day, like,
Yep. 2 to 3 loads, two cord loads. That's what I've been trying to work. I've got,
so any day that you have recorded as you cut?
Yep.
Am I right in assuming that maybe there's 3 hours is the most you're actually running the saw?
it depends. Sometimes if you get a crooked log and I have to jump onto the deck with a PV and roll it or something like that, that does add extra time. Generally, every time I have cut this calendar year, it has been at least 50 minutes or less that the processor has been above recorded decibel levels that are allowable for the town. I believe in the appeal or the first initial complaint, it was saying that one of the residents next door had 75 decibels at their front door. The only time that it is above that is when the machine is operating. The log truck is below that. My delivery truck is below that. But I did want to address that as well, though, because in the homeowner business supplemental application to start a business in your home, it specifically states that agriculture and forestry operations are exempt from any performance standards in the town of Underhill. And the appellant's representative, I feel he even stated that my processor is portable. Why don't I just move it somewhere else? In the specific definition of a sawmill in the town statutes, it says that portable equipment used in the processing of forestry products and other timber related is not a sawmill. It's excluded from that definition. So at this point, I believe that we need to figure out what it actually wants to be classified or what you folks would like to classify it as in order to figure out if I'm an on-site forestry operation or an off-site forestry operation. If it's on-site, there is no timeline of 12 months, 24 in a 12 months of operation in a 24-month period or 24 months of operation in a 5-year period, excuse me. Offsite operations, they do have the timeline. On-site, there is no timeline because you can have a continual forestry operation in timber harvesting or like people that have current use plans. You have to have a forestry operation plan or a forestry management plan in order to have a current use plan. So if you're in current use, you have to manage your timber. And so that would be continual. Every 10 years, they have to update. And if the forester says you need to cut some timber, then it needs to happen, whether it's harvesting blowdowns or select cut and marked like the neighbors are doing just up the road. That's what the current use is. That's using your land and managing your land. And I'm just the steward that makes the noise with the processor. So if it was quieter, I would much appreciate it. But unfortunately, that's what it is. I try to be cordial and not operate early. I don't go down there thinking, oh, hey, I'm going to go make a bunch of noise and tick the neighbors off today. They don't cross my mind. I focus on my clients, my people that I have to deliver to, and the wood that I need to put out that day, and then the logs that need to come in from landings and other loggers in the area. They do not cross my mind. I'm not there for a job or to see how much I can tick them off. It's not a thought of mine. I'm just a veteran hermit that likes to mind his own business and do my job and provide for my family just like anybody else in this town. Any other questions?
Karen McKnight. So you say you operate between 8 and 5.
Yes, ma'am.
When you do operate. But how many days in a row successively typically is that? Is it like 5 days a week for that 79 or is it 2?
No,
or
79 days. I actually have it right here.
It's kind of on the average. It's not 5 days a week.
No, absolutely not. For 2023, pardon my hen scratching, I have 8 January, 24 January, 5 Feb, 16 Feb, 18 Feb. There were 2 loads that went out that day. March 1st, March 3rd was a good day. I got 3 loads out that day. March 9th. Then I stopped till April 14th, April 24th, May 5th, May 19th. And then I believe, 6/1, 6/21, Yeah, they're very sporadic days. It's not a everyday, 8 to 5 job. It's maybe 1 or 2 days a week. As I get orders coming in, I go down and cut them. Unless I have breakdowns, some days it is repetitive 5 days a week. I was broke down for the whole month of July, and I had 88 orders of firewood, or 88 cords of firewood that I had to catch up on cutting to get in. July is kind of the make or break time for green firewood deliveries. If you get it in July and stack it at that point, it should be seasoned with the term of length that it's been cut, log length on my landing, it should be seasoned by the time it's cut, split, stacked, and drying. So July, August is kind of the make or break time. At that point, people are just getting stuff for the following year burning. So if I'm not broke down, God willing, that it doesn't happen a lot this year, it'll only be a couple of days a week, if that. If I get 4 or 5 cords for orders in a week, I can knock it out Monday or Tuesday and spend time with my 2.5-year-old the rest of the week. I don't need to cut 5 days a week. I don't have the orders for it. I'm not huge like West Alls or Craig Walker or anything. Last year I did 265 cords. The year before that I was 325. Last year was a warmer winter, so people didn't order a lot of extra wood. It kind of comes and goes, and I don't cut, specifically religiously every single day. So, yeah. Any other questions?
You're up to 300 cords right now, approximately?
No, right now I've done two.
I'm sorry, I mean over the course of a year.
In the course of the year,
grown quite a bit.
Average 250 to 350, I would say. It really depends. Last year, I talked to 3 or 4 other firewood cutters within a 10 to 15 mile radius, and they were down about 100 cords. So my 325 to 265 wasn't out of the normal. Miners in Cambridge said he was down about 75 cords. I know there's a guy in Fletcher that was down about 100 cords last year. It's just because of the warmer winters that we've had. We don't cut as much. This year, we had a little bit of a cold snap, but not really much. I don't expect to be over 300 this year. If I am, it's because I get more clients. I know Putnam's on Route 15 in Cambridge have shut down their firewood operation, so that will probably be sending a few more my way. But they have miners up on North Cambridge Road that cut as well that are comparatively priced, and the Sean Bishop over in Fletcher, he also cuts, and he's very local to them. So it's just choice of people. People are very finicky. They choose their firewood producer, and they usually stick with them. And like I said, West Alls have been here for years. Craig Walker's been here for years. Jeff Sprout's been there for years. These guys are all 50, 60 years old and older, and I'm the youngest guy that cuts an Underhill. I try to be competitively priced and provide a good service for them. But,
so I was just curious how big you would expect to get on that size.
I honestly don't want to get over 400 cords. Since I do truck in my own logs, a lot of that does happen in the wintertime. I don't cut after deer season. Usually November 15th is the last I'd like to cut. I'd like to be done. Honestly, if I could be done by October 15th, I would be much happier because then I can spend time in the woods hunting and getting ready for winter and logging season, prep my truck and get all that stuff. The only activities down there during the winter months are me hauling in logs and stockpiling for the year. My processor is packed up and removed from the property, and I do service on it if I can. But I don't cut from November to at least April. It's just too soft to get in there, and it's too cold and hard on the equipment for hydraulics and stuff.
And so how big is that piece of land that you're leasing, and could you in fact stockpile a lot more logs there, or are you maxed out the room?
Generally, speaking with Shane and Joe, I believe the section that they've kind of cut out for me is 5 to 6 acres.
And how much do you use now? A couple of acres? Or?
Yeah, it's very close. And with all the repairs I had to do to my truck, I didn't have the ability to buy a lot of logs like I had planned. I would like to have a stockpile drying of maybe 150 cords. The pile that's down there now is probably about 40 to 50 cords in log length right next to the road. But I would like to have potentially about 200 cords on hand just from September to Probably mid-July is when I would probably go through that.
Okay, thanks.
Yep. Anything else? Thank you.
Anybody else from the public like to speak tonight? Okay. Would you like a chance to respond to any of the public comments received? Okay.
Thank you. I want to reiterate, this isn't about wanting to shut down Mr. Williamson's operation. Zoning is about where you cite things that we all, for the most part, agree are beneficial activities. Heavy industry is beneficial. You don't necessarily want it right across your property line. As Mr. Williamson said, there are periods where it's 5 days a week. And those periods, if I understood his testimony, are in July, in August, when you have your windows open, when you're outside. And so it's very disruptive. And, he does important work. If I lived up here, I'd probably want to buy firewood from him. But this isn't about whether what he does is beneficial in the abstract. It's whether you as a town have decided that's the place it should take place. Mr. Williamson suggested that a portable sawmill is excluded from regulation under your bylaws. If you look at the definition of a sawmill, it's clear that portable sawmills are only excluded to the extent that they're being used in connection with an on-site timber harvest. So otherwise, if you're bringing in wood and chopping it up on-site, that's just a sawmill, whether you can move it somewhere else or not. And it's not permitted. I think that's all I want to comment on.
Yep, Brad, we'll let you also respond.
I would say that I didn't see anywhere in the sawmill definition of sawmills where the logging is taking place. It reads portable chippers and sawmills used in conjunction with active logging operations are excluded from this definition. And I realize that the statute that I'm referring to is under court procedures. But it's oftentimes, and I'm no attorney, believe me, and I'm not even pretending to be one, but I've seen legislation all over the place. I've seen our timber trespass laws and in laws with milk incubation, so it, but I will say that in the definitions, so what we're looking at here is Title 12, court procedure, the Vermont right to conduct forestry operations. And in the definitions, just as Attorney Barnard pointed out, is where I'm taking the 5 criteria, but it also defines forestry operation. You can go round in circles here, is a portable sawmill that's processing timberland or timber wood coming off a forestry operation, a sawmill, or isn't? I don't know. But I guess I would just ask simply, I see there was some new information brought tonight that I didn't get an opportunity to review, unlike the packet that was included here for the last 15 days. I would request that you extend the evidentiary portion of the hearing until your next regular meeting. This is a request. So I can have the opportunity to review what was submitted and comment. Thank you.
Thank you. So we do have the ability to continue the hearing, and that would give Brad the chance to review what was submitted tonight, respond. It would also give the appellants a chance to review and respond to any comment that was received tonight. Our next hearing is May 20th. We have another project on the agenda. Does the board have any thoughts on extending this hearing till May 20th to allow the chance for any new information to be presented?
I don't have a problem with that, but I was wondering if we could extend it a little bit unless we had a special meeting. I won't be at the May 20th meeting, and there might be an issue with quorums.
I would say I don't see any reason to extend. I mean, I feel like I'm ready with what I've heard here to render an opinion, but I can be here at the 20th also.
Okay. So other thoughts on that? We don't necessarily have to extend it to May 20th. I know in the past, on past projects, we've kind of met in special session, but we would need to we could set a deadline for the additional information to be submitted of May 20th. And then, that would give us time to process that information. We have to continue it to a date certain, unfortunately. Not sure who else is not going to be available on the 20th. Yes. Yep.
I would just ask that the DRB decide the issue, which is really a legal issue, on the information that's been provided tonight. It is unusual in my experience appearing before DRBs to have the zoning administrator play such a role as an advocate and ask for an opportunity to respond. The issue is really before the DRB at this point. The landowner has been heard. My clients have had a chance to have their input, and they're residents paying for me to be here. I don't want them to have to pay to have an attorney come to another meeting when I think you have everything you need to resolve this issue. But obviously we will be happy to appear again to the extent that you need to consider further information.
Yeah, I would just say I'm okay with that as well. So we don't need to belabor this any longer. And Attorney Barnard's correct. So I would like to, we're going to obviously have to add that into the record tomorrow, and I'll help Matt do that on the website. So it's a part of the record. Thanks.
Okay, so both sides are okay with with the information submitted tonight. So next, I'll ask the board if they feel they have enough information at this time to make a decision on the application.
I'd just like to talk a little bit more about the definition of sawmill.
Yep.
As a board, can we do that?
Yep, we can.
Okay. So can we look at it? It is. Hello. Okay, thank you. Yeah, I just want to just it's all on how you read it, right? Have we all read it here?
Yes.
You're reading yours? Okay. Sawmill, a wood processing facility, including structures and yards where logs are stored and processed into lumber and other wood products. Portable chippers and sawmills used in conjunction with active logging operations are excluded from this definition. And then you've got your forestry, the use, which is allowed in this district, the use and management of timberland for purposes of conservation and/or wood production and timber harvesting. This definition specifically excludes sawmills, lumber yards, and other similar facilities used for the processing and/or manufacturing of wood and wood products, with the exception of portable sawmills and other equipment used on site in association with timber harvesting activities. By this, it's not a sawmill. I don't think it's a sawmill.
It's a portable. Yeah.
But I want a discussion. I want to hear
Shani,
from our team.
could I first ask you, where are you reading from? Are those?
I'm reading from our regulations.
All right.
And I am,
what page?
I don't know, I'm not particularly, It's the definition section.
Yeah, what,
So
just
you
what page?
You go in alphabetical order.
The
And it's on
page?
page 198 is forestry, and on page 208 is sawmill. They kind of, point to each other. So I think we should read that before we make decisions and everyone interpret it the way that they see it. Do you need this? Do you want to read this? Is it in there?
It is in there.
It
but
is
we
in
just
both
make sure they're the
sections.
same.
Yeah, this is forestry, and then this paper's where the sawmill is.
Which,
Same?
Yep.
Okay.
so does anybody have an opinion on the sawmill? We also have the option to close the evidentiary portion of the hearing and go into deliberative session.
Hi, Meg Armstrong. I think from what I've read of our definitions and from the state statutes that presented, it appears to me that Mr. Williamson is 100% within state laws on forestry operations. And I have a hard time understanding how you can feel differently. When I hear the word sawmill, I think the sawmill like on Route 15 in Essex. Structures, kiln drying, all that stuff. A portable sawmill. When I think portable sawmill, normally I think of something that's, out on, I'm in current use, my, land to cut up some rough cut hemlock that's blown down or whatever. But a firewood operation, and when you're saying you're running 79 days a year, 2 to 3 hours a day, I think that totally falls within the definition, both in ours and of the states, of forestry operations, not sawmill. And which is allowed in this district. And I think of it as similar to Mike Timber's thoughts on right to farm, there's a reason why you have a view of Mount Mansfield. It's because people are logging.
Penny?
Brian, this is Penny Miller. Could I just ask a question, just a more factual question before we get into interpretations? I just wanted to ask, I believe this comes from the attorney's office, this submittal that came today. I just wanted to ask if, because I'm looking at it quickly, how much of it is different than or the same compared to what we've had already? So the memorandum is new. The Exhibit A, I don't want to miss anything. Exhibit A, we have already seen before. All right. Hold on. Part of Exhibit A. Let me just.
Not A. You're probably thinking that's the D.
No, we have received A. This is from Mr. Williamson.
So Exhibit A, we've seen before. Exhibit B, we've also seen before.
Yes.
All right. So it's basically all that is new, and that are the photographs and the introductory. Okay, I just wanted to be clear about that. Thank you.
But I think we're done our evidentiary period, right? So now we are really kind of gone already into deliberation, right? I second that motion.
All in favor?
Aye.
We've closed the evidentiary portion of the hearing, and we have the option to go into deliberative session. Does the board want to deliberate in open session or closed session? Closed session? So we vote on? Okay. So we're going to go into deliberative session. We have the option to do that tonight. in closed session. And
I'll make a motion to deliberate in closed session.
I second that motion. Aye.